Welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today I have one of my spring 2025 legal interns, Teghan O'Connell. She's been doing a great job and she still has a little bit of time left with us. Anyway, it's been great having you, and thank you for being part of the program. Teghan, why don't you tell us a little bit about yourself, tell the audience.
I'm a sophomore psychology and justice studies student at the University of New Hampshire, and I'm hoping to pursue a career in law, so this has been a great opportunity to learn about the industry.
All right, well, hopefully you've learned something so far. I know you've done a lot of research for us here. Why don't you, and I believe you have some questions. So what's your topic and what's your questions?
So my topic's kind of just a broad coverage of the authorship of intellectual property works, and the effect that AI will have on this authorship. So the first kind of question I have is about, so the U.S. Copyright Office released a report in January of 2025 discussing the copyrightability of AI-created works. Before they released this report, however, Dr. Stephen Thaler filed a lawsuit because he was attempting to copyright an image that his AI machine created, and he wanted to copyright it with the author being the machine.
Right.
Do you think that it changes anything for this case? It was ruled that the machine can't own this, but do you think the fact that he owns the machine makes it that he should own the subsequent works from the machine?
Well, in both the patent field and in copyright field, the Copyright Office and the USPTO, they've both said that merely owning the machine or possessing the machine or setting up the AI algorithm is not sufficient. And I don't, otherwise you're just like, okay, let me just buy the algorithm from someone. You're not, just because you control it. So in that respect, I agree with the USPTO, the court decision, and the Copyright Office.
Do you think it would change anything if this was a private AI model trained on data specific to the issue that the person who created the machine owned?
That's an interesting question. And if the owner in a private AI model had a significant input in doing the training to get to that point, then in a way it's kind of, to me, and with respect to prompts, they're educating the robot in the inventor's knowledge, and it's not subject to the public. The public doesn't have access, and it's a significant contribution to the training process. I would say that would make a difference.
Now, the U.S. Patent and Trademark Office and the U.S. Copyright Office have both set guidelines for self-disclosure when it comes to the use of AI in applications and trademark, copyrighted, and patented material. Do you think it matters whether people actually disclose the use of AI? Do you think that if somebody applies for an application and they used AI to help create the material of the application, the disclosure or non-disclosure is actually relevant?
Now, who did you say requires this?
The U.S. Copyright Office specifically, and the U.S. Patent and Trademark Office under their previous presidential administration report.
It's required to disclose that AI has been used for the U.S. Copyright Office. There is no requirement in the U.S. Patent and Trademark Office to disclose they used AI.
Do you think there should be?
That's a good question. I mean, it's going to, the issue is going to come out when it comes to enforceability, and then a big issue which I see as far as a lot of litigation going forward is who's the actual inventor and how much did AI contribute. I think if you're just going to have some brief statement that AI contributed to this, I don't think that's very helpful. So then it gets into, well, how much disclosure is sufficient to say, well, AI did this? And then even in copyright, you don't have to disclose, I believe, what exactly AI did. You just have to disclose that AI, and then the Copyright Office can ask additional questions if they want.
And then one of my last questions here for you is, the USPTO is expected to release a new set of guidelines around the operation of AI in the patent and trademark application process, in accordance with the current presidential administration. Do you think these are going to differ from the previous guidelines that came out under the Biden administration?
Well, you have lots of good questions, so I think it's going to be different. I don't think it's going to be substantially different. This is not, to me, an issue, Republican, Democrat, conservative, liberal. It doesn't break necessarily along party lines. So there's always in IP and in patents, there's different interests with large company, small company, government, the research institutions, universities. So I think if there's differences, it's more the interaction between those types of parties than just we're moving from a Democratic to a Republican administration. It'd be kind of interesting. I mean, I'm not sure how much radically different. The guidelines were fairly simple, but I guess one never knows, and we'll be stay tuned for what will happen.
Yeah. And my last question here is, do you think generative AI will play a role in the decisions considering obviousness in the U.S. Patent Office decisions?
Yeah, I do think generative AI, because especially if it's like public AI, then it's something that's publicly available to one of ordinary skill in the art. I think it's going to be one factor, and then it becomes providing evidence to show whether one of ordinary skill in the art would be able to get the information from generative AI. If you just say, well, what improvement could you make, and then it spits out something and that's all that was needed, I would say that's a pretty good indication of obviousness. But if there's kind of a lot going into it to provide the background and the problems and the drawbacks and stuff like that, again, it's all case specific. But if it's available to the public, that's just another piece of information, just like prior art is, just like patents, publications, technical journals. So in that respect, yeah, I do think it will play a part.
Well, thank you for answering my questions today. It was nice talking to you about this.
It was great talking to you, and I think she did an excellent job, and I look forward to the next few weeks. And to everyone tuning in, thank you, and I look forward to seeing you on the next episode of Unraveling Intellectual Property with Michael Stein.